Right, hi again. So we are going to be checking in with you guys about the week 2 readings. We're going to start off talking about Just Mercy chapters 1, 2, 3. So in these first 3 chapters, Bryan Stevenson is introducing us to himself, how he graduated from law school, where he went to law school, as well as why he ended up representing death row inmates and how the first few times he went to death row kind of has impacted him. He's also laying the stage for the scene of a common theme throughout this book, which is poverty and race and limited access to justice. These themes are backed up with research. Research does show us that individuals who are non-white receive harsher punishments for the same actions and are more likely to get the death penalty than their white counterparts. And so he is giving you examples of this from his own experience. For one thing, by being hit poor interactions with the police when he was actually a young attorney, and then as well as describing kind of some of these interactions on death row. And it's unique to see kind of this intimate perspective of what death row actually looks like. He is also introducing us to a case that is a theme and a case that is going to run throughout the rest of the book. The case of Walter McMillan. So Walter McMillan was accused of a crime he did not commit. There was a murder of a very popular, well-known young woman in this community, and the police were stumped as to who could have done it. Walter had a reputation for being promiscuous, for having affairs, including affairs with white women, which was an unforgivable kind of sin in this community at this time. Eventually, he is framed for this based on the word of someone who was known to not have any credibility, who was seeking to benefit by getting a better deal for himself. So kind of threw Walter under the bus. He recants his story multiple times throughout our reading of it, but Walter is still arrested, and instead of waiting in more of a county facility, which is where most people await their trial, he actually is sent directly to death row before anything happens. So Bryan Stevenson is introducing us to him. So as you read through these first 3 chapters, if you're coming up with anything that you don't understand, is unusual, feel free to let me know. Again, we can talk via email, via phone, or through WebEx, which is essentially like a Skype. Also noting that this book can be challenging to read because some of the topics and themes are things that make us pretty uncomfortable. But I hope that you're able to kind of stick with it. Additionally, I'll note here explicitly that if you are someone who has trauma in your past and this book is too much for you, please reach out to me and we can make an alternate arrangement. Okay? So starting with today, I want to talk to you a little bit about this week's course pack readings as well. So last time we talked about the idea of stare decisis and precedent, which is very, very important to the Constitution, to the readings and work we're going to be doing this semester. When something is not able to go through precedent because it's new, judges will frequently start with the text, and then they will if that's not clear, sometimes go to the legislative history. So an example of this happened in United States v. Bond in 2014. Carol Ann found out her best friend was pregnant by her husband. She was extremely angry and felt betrayed. Carol Ann was a microbiologist and at work had access to some chemical compounds. She took some home. She also ordered some other chemical compounds from Amazon.com with the intent to use them. She did not intend to kill her friend, but just to cause a bad rash. And so on 24 different occasions, she went and kind of spread it on her car door handle. She spread it on the doorknobs, on the mailbox. And one time, her friend got a super minor chemical burn that she treated at home, just kind of with the at-home remedies, like running it underwater. But Carol Ann was charged under federal law for possession and use of a chemical weapon. And so this case goes all the way to the United States Supreme Court, and the Supreme Court overturns that because when they looked at the legislative history, Congress didn't intend to capture behavior like Carol Ann's. They were more looking at capturing terrorists or potential terrorists. So sometimes when things are not clear, we see the courts going into what the legislators tell us this law meant. Another really important concept is this idea of the Incorporation Doctrine. So when the Bill of Rights, the Constitution, was first adopted, these amendments did not apply to the states. They only applied to the federal government. Slowly over time, we have incorporated most of the Bill of Rights, with the most recent incorporation happening February of this year in part of the Eighth Amendment, the Excessive Fines Clause. So these first couple of cases are dealing with civil rights and civil liberties, as well as should the states be bound to comply with those Bill of Rights. So this first case in our course pack, Powell v. Alabama, this is from 1932. We have the Scottsboro boys being arrested and charged with rape. They were falsely accused. The victim later recanted. Nobody in the community was willing to represent them, and the state had a law that defendants must have trial attorneys, and these young men did not get one. They were held under military force. They were physically beaten by police officers. They were threatened, and then there was a lawyer who kind of showed up at trial, but who also told the judge that he was not prepared to handle this. And so the question before the Supreme Court is, did the trial court violate the 14th Amendment by not giving these young men the due process required under state law, by not giving the appointment of counsel in this capital case, because these young men were all sentenced to death in 3 trials that took place in less than 1 day, which is unheard of. Most capital cases, the trial lasts for 5 to 10 business days. Okay, so did the trial court violate? And the Supreme Court said yes. These defendants were not given a real attorney. And this is a requirement for capital cases, and it violated due process. What makes this, and this kind of seems, of course they are entitled to a lawyer, of course that they violated by not letting them have an attorney to us, but this was one of the first times the Supreme Court waded into an arena of state criminal law and said, no, you violated these defendants' constitutional rights with your conduct. Okay. So the next case we're going to talk about shortly here is Mapp versus Ohio. This is a landmark case. You can see here a picture of Dalry Mapp, and Dalry Mapp was kind of involved with some of these underground betting and bookie procedures that related to kind of boxing in Cleveland that was underground. The police thought somebody was hiding in her home, and so they arrived and asked to look around. Well, Dalry Mapp, based on these connections to this kind of underground gambling ring, had a lawyer on standby, and she called that lawyer and said, police are here and they want to look around. And the lawyer told her, if they don't have a warrant, tell them no. They need to go get a warrant. That's what the Fourth Amendment requires. Say no. So she did. The police told her they were going to go get a warrant, but they left for a while and came back with a blank piece of paper. They barged into her door, flaunted a blank piece of paper that she grabbed and put down her dress, that they then went down her dress and ripped out and then tore into pieces. They searched her home. The person they were looking for was not there. that was not there. But they did find some pornographic materials in the basement. So this was in 1957, and there were laws about pornography and obscenity. These were from her former tenant in an apartment, and they were essentially kind of like Playboy magazines. And so she was charged with a crime for possessing these Playboy magazines. And this was appealed all the way to the United States Supreme Court, kind of examining this exact question. Were these confiscated materials, those confiscated Playboy magazines, protected under the Fourth Amendment? And we have the Supreme Court for the first time saying, yes, the state police officers violated Dalry Mapp's Fourth Amendment rights. They violated her constitutional protections. They had a duty to get a warrant, and they did not do so. Therefore, those magazines they seized are not admissible against her in a court of law. So the conviction was overturned. This was a huge deal because before this, state police officers did not have to comply with the Fourth Amendment protections for unreasonable search and seizure. Federal officers, FBI agents and such did, but your local, your sheriffs, your county police officers had no duties to follow the Fourth Amendment. So this was the very first time the Fourth Amendment starts to apply to states. So this is a really big deal in this case, and we're going to talk about it again a little further down the road. Okay, so that is kind of it for this topic. If you're interested, there is kind of a recent Supreme Court case, and then below that we have some of the Federalist Papers. Those are not going to be mandatory readings. Okay, so if you have any questions or thoughts, please let me know. I look forward to hearing